morning and welcome to Law Talk with Ethel Mitchell. Now for today's show, here's attorney Ethel Mitchell.
Welcome. I am your host, attorney Ethel Mitchell. I welcome all who are listening live throughout the world on Radio 1 Station, 1450 AM, WOLDCnews.com, and LawTalkWithEthelMitchell.com, and over the free TuneIn app. This program is brought to you by my law office, Wills and Trust, LLC, where I prepare wills, trust, power of attorneys, and advanced medical directives. If you or someone you know needs a will, a trust, or assistance administering an estate, call me at 202-772-1988. 202-772-1988. For those who may have missed our big announcement last week, this radio program, Law Talk with Ethel Mitchell, is growing. We are expanding into an hour-long format. Beginning in July, we will be airing from 9 to 10 o'clock. This will give us more time to bring you more information and to receive your questions and comments. So remember, set your clocks to hear us earlier from 9 to 10 o'clock beginning July 5th. We will be on the air for a full hour. Same station, same websites. Tell your friends and listen in. I want to start today by wishing all the wonderful fathers happy Father's Day, and a very special happy Father's Day to all the black fathers out there. I want to tell you all that I have such admiration for all fathers, but particularly for black fathers. You all get a hard way to go sometimes, but there are a lot of great fathers. There are a lot of great black families, and we need to support them. And in my family, the women cook for all the men on Father's Day. And it's a big deal. It's a big deal. For Mother's Day, the men cook for the women. But we celebrate each other and we support each other. So I encourage everyone to say Happy Father's Day to all the many fathers out there. Law is powerful. It can help you or it can hurt you. It impacts everything you do. What you don't know really can hurt you, but what you do know can really empower you. So each week, this program aims to empower you by bringing you professionals who know the law and or related fields to enlighten and inform you. This month is National Home Ownership Month. Last week, Attorney Yolanda McGill with the National Lawyers Committee for Civil Rights Under the Law enlightened us about foreclosure scams. They are very sophisticated, shockingly so, and she gave us a lot of great information about how to fight back if you believe you have been scammed. Remember, all of our programs are archived on www.lawtalkwithethelmitchell.com. So if you missed a program, go there, and the programs are posted by my webmaster, Earl Hooks, within 32 hours of their airing. We want you to be part of the conversation, so write this down. My executive producer, Stacy Royster, is standing by to receive your calls and your comments and questions. Call us at 1-800-450-7876. I'm sorry, 1-800-450-7876. Tweet us at LawTalkEM. And like us on Facebook.
Good morning and welcome to Law Talk
with Ethel on Facebook. I must remind you, as always, that what you hear on this program is for information purposes only. No attorney-client relationship is established by anything said on this show. Each person's circumstances are different, and you must seek individual counsel for any situation for which you need legal advice. So let's get started. According to the U.S. Census Bureau, 64.8% of the United States own their own homes. As we explore home ownership resources and solutions, I intend to dedicate this program to helping you to understand various ways to own title to a home. It can be a wonderful and powerful way to, accomplish your objectives. And it's the kind of information that you're not going to get on LegalZoom. It's the kind of information that you're not going to be able to take advantage of if you just try and go and, download some form. Lawyers like myself who are estate planners know how to advise you and guide you to accomplish your objectives. And home ownership is something that is critical to maintaining strong families and keeping us all housed, which is important. It's critical. So we're going to flip the script, as we say today. I'm going to be the guest, and Stacy, my executive producer, is going to have a conversation with me and ask me questions about owning the home and how you can do it in many different ways. So, Stacy, welcome.
Thank you, Ethel. Good morning.
Good morning. Good morning.
With more than 20 years of legal experience, Attorney Mitchell has distinguished herself as a leading practitioner focusing on wills, trusts, estate planning, and probate. She is a sought-after legal advisor and frequent legal affairs orator. Mitchell is a member of the Bar Associations of Maryland, Washington, D.C., Virginia, Texas, United States Virgin Island, and Ghana. She completed undergraduate studies at Fisk University, and she received her Juris Doctorate degree from Columbia Law School and then served as law clerk to Chief Judge Christian in St. Thomas, U.S. Virgin Islands. Passionate about educating people to use the law proactively to empower themselves, Attorney Mitchell continues to engage her listeners about various aspects of the law and how it directly impacts their lives during her weekly broadcast, Law Talk with Ethel Mitchell, which she aired in February of this year, right here on Radio 1's WOL 1450 AM. Thank you, Ethel, for sharing your magnificent expertise with your listeners.
My pleasure, really.
Okay.
It makes a difference. Yes.
So as Ethel said, we're going to flip the script and I'm going to interview her, or rather have a discussion with her. We want you to be engaged. Remember to call us with your questions or comments at 1-800-450-7876. So Ethel, for those that are not aware, what is a title to a home and why is that important?
The title to a home determines who owns it. Doesn't matter what somebody says to you. Doesn't matter that mama said you were going to get something or daddy said he was going to do something. The title to the home is what is recorded at usually it's called the Office of Recorder of Deeds in the county or the state in which you live. It is a public record. In some states, the will can be recorded, but in most states, you need to have an actual deed that is recorded, and that is truly the only place that you know where somebody owns something. Okay, and it's really, really important. Really, really important.
I can imagine it's really important when it comes to more than one person owning a home. So talk to us a little bit about a title held as joint tenants. What does that mean?
I'd be glad to talk to you. Let me tell you one thing, though. Never put somebody's name on your deed if you're not absolutely certain that you want to keep them there. Okay, let me just say that right up front. I have several clients who have put their husband or their fiance on their deed, and then they break up. Once somebody's name is on your deed, you cannot unilaterally go and take them off the deed. They have got to agree to come off the deed and sign the paper. So let me just start right there. That's why title and deeds are so very important. So joint tenancy is one of the ways in which we can own the title to property. Joint tenancy comes in two forms. One is called tenancy by the entirety. That is only available to married couples. So when you are a married couple and you buy property together, then you say to each other, the deed will say to Jane Doe and John Doe, as with tenants by the entirety. Not only what does that mean is that when one dies, the other one owns it outright, but it is one of the strongest, most secure forms of asset protection there is in the law. Because tenants by the entirety, unlike any other title, means that even if one of the married couples gets a judgment against them, the creditor cannot force a sale of the house if the house is owned as tenants by the entirety. Mm-hmm. It is a very tight form of ownership, and it cannot be broken while both parties are alive and both parties own as tenants by the entirety. So it's really, really a very strong way of owning property.
You mentioned only married couples. What about domestic partnership agreements? Is that fold?
I don't know as yet if that has been accepted. Okay? Mm-hmm. So we can ask somebody, I will ask somebody who is familiar with those laws. But I know that right now, only married people, which may well include, since people who are gay can now marry in many places, so they may be able to receive the benefit of tenants by the entirety. Mm-hmm. The second form of joint tenancy is joint tenants with rights of survivorship. This is a form of ownership that is very, very useful. A lot of my clients own property together. They may be sisters, they may be brothers, they may be fiancés, they could be anybody where you own property, more than one person, and your intention is that when one person dies, the other one will own it outright. That's
so
the rights
their name
of
is on the
survivorship.
deed now.
Absolutely.
But they
both
only...
names have to be on the deed. Mm-hmm. It can be 3 or 4 people, actually. I've seen 3 or 4 people on it. Mm-hmm. And what it says is all of these people, number 1, 2, 3, and 4, own the property as joint tenants with rights of survivorship. And what that means is when number 1 dies, number 2, 3, and 4 now own it.
Got it.
When number 2 dies, number 3, 4 own it. When number 3 dies, now number 4 is the only one that survives, and they own it outright. Okay? That is an excellent way of keeping property in the family when your intention is that only those persons are to get that property. You don't want it to go to their spouse. You don't want it to go to their children. You only want it to go to the named persons that are on that deed.
That's very interesting. It's so necessary, and a lot of people probably just don't understand.
It. That's why I decided to. Yeah. That's why when people come to me to do estate planning, one of the first things I ask for is a copy of their deed. Because I want to look and see, does it say what they expect it to say? And as I'm working with them to accomplish their objectives, for example, maybe a mother wants to have her adult children, never put a child on a deed, please. That's a whole nother conversation. But a lot of times people will want their adult children to get it. But and the mother will come in or the father will come in and say, I want to give the property to my children. But I say to them, well, you know what? What happens if they die before you? If you are joint tenants with rights of survivorship, then if the mother dies or the father dies first, then the child owns it outright. Okay? The problem with joint tenants, even with rights of survivorship, however, is it does not give you the credit protection that the tenancy by the entirety does. So even if you have joint tenants with rights of survivorship, the creditors of those joint tenants can still kind of get to your title. So that's another thing that you have to be careful about.
That is a lot. You are really taking us to school today because just in this first few minutes, I'm learning a lot personally. And I know a lot of people that I come in contact with, it's just really, really, interested in knowing all these
different things. If you are, for example, if you live with a fiance or someone, and you all been paying the mortgages together, and so on, then you may say, okay, if I die, I want my fiance to have that property, then this is when you might put that person on your deed with rights of survivorship. But again, only put them on there if you don't mind, because you can't make them get off. Okay.
I know we have to take a little break, Ethel, but as soon as we come back from break, I want to talk a little bit about tenants in common and what that is. So we'll take a break right now. I'll be right back with Law Talk with attorney Ethel Mitchell.
WOL.
I'm Dr. Mary Harris for Journey to Wellness. Around half of the current 90,000 patients on some kind of organ donation waiting list are African Americans, but there is a shortage of Black organ donors. Victoria Dent, chairman of the Linkage to Life program, says part of the problem is that potential donors don't tell anyone about their donation decision.
Make sure that you inform your family because they make the final decision for you.
The Links organization has published the Can We Talk Conversation Guide.
We'll give them tips on how to start the conversation and how not to focus on death, but focus on life.
And research shows that the transplant gift is more likely to be successful with a better tissue match that shows up among the same race. If you'd like to be a donor, Dent suggests
see if their state has a state registry. They can also sign the back of their license or a donor card.
There's more at JourneyToWellness.com. I'm Dr. Mary Harris.
Thank you for tuning back in with us here at Law Talk with Ethel Mitchell. I'm Stacy Royster, executive producer of the show and guest host today. Our regular host, attorney Ethel Mitchell, is the guest of the day, and she's talking with us and really educating all of us about various ways of owning title to a home. I want to encourage all of you, if you have questions about various titles, various ways of title ownership, please call us at 1-800-450-7876. That's 1-800-450-7876. Again, we're talking with attorney Ethel Mitchell, and her law practice sponsors this show. Thank you, Attorney Mitchell, for joining us.
My pleasure.
A lot of great information. I want to talk about what is a title as tenants in common. What in the world is that?
That is where each owner, each person whose name is on the title, owns a share of the property. You see it a lot in what we call heir property. Okay, your grandfather owned some property. That property went to his children and then to his children's children. What happens is each person on that property owns a particular percentage of the property. So let's say originally it was owned by 4 siblings, okay? Because they are separate, even though it's undivided ownership, it means that when one of them dies, their heirs now own their share. So let's say 4 people own the property, each owns a 1/4 interest in the property. When one dies, their 1/4 interest, let's say they had 2 children, it gets divided into 1/8, 1/8. You see what I mean? And so it becomes rather difficult to manage because one tenant can force the sale of the property, because they want their share. Even though they're only going to get a particular percentage, they have the right to force the sale of the property. But each tenant goes to their particular share, to their particular heirs, and so that's how you end up with a lot of property, especially in our families that owned a lot of property all over the country with, 20, 30, 40 different people owning parts of this property. Because it's automatic if the deed doesn't say differently. If the deed doesn't say joint tenants with rights of survivorship, then the law presumes that it is tenants in common. And that's how you get it all divided up into all these little pieces.
This might get tricky, but so I'm thinking about, what about so-called legitimate children versus illegitimate children?
Oh, that's a whole other conversation.
Okay, so when it talks about stepchildren and so forth, children by marriage, and one of the parties dies, I guess we need to everybody make an appointment with attorney Ethel Mitchell.
Yeah.
Tell them how they can reach you.
That 202-772-1988, because you can make it clear as to who you want to get your share, but you've got to make it clear in writing. And you're going to look to, if you don't say anything, then you look to the law of the state where the property is located. So if the property is in Virginia, even if you live in Maryland, you look to Virginia law to determine how the title to the property distributes that property.
That's very key. I guess it does vary by jurisdiction and state.
It can. Okay. Yeah, it definitely can. Yeah.
So is there anything else about tenants in common we should know?
It's just very difficult to deal with.
Okay, we have a listener that's calling in from Maryland. Go ahead, caller, with your question.
Yes, if you have property that the deed and trust and the deed of release mentions joint tenants in entirety, the parent's name, and heirs and or signs. The deed does not have that. Possibly the recorded deed said because of the age of the deed, that information was missing.
I would have to look at that, very honestly. It's going to be hard to talk in because, number one, for example, you said deed of trust. A deed of trust is actually a mortgage. A lot of people
it
get
mentions
that
the
mixed up.
heirs, where it was to the point my mother actually hand wrote their heirs in the body of the deed of trust. The deed of release, by the time that was written, she was deceased. My dad is now deceased. My sister predeceased my dad, and she had a son.
Again, that's where tenants in common probably, I'm just guessing here, that the ownership is going to be tenants in common, because once your mother and dad died, if they had tenants by the entirety on their deed, then whoever was the latest one to die, they own it all, okay? So then when they died, their heirs would own it. And that's why you want to encourage your parents to have a will that says, okay, when both of us are dead, this is who gets it. Or use one of these forms of deeds to make it clear who they want to get it, you see.
Now, does that mean that's heir property, though, by saying on the deed of release?
It sounds like it.
How would that be proven? Because there's a new law.
Miss, I'd have to look at it. I'd have to know what state it's in.
It's
and I
in
really,
DC.
no. I would have to really look at it and find out all the facts surrounding it before I could really tell you. Okay, I'm sorry, but that deeds are something you have to actually look at, and then you would tell me like a history of who died when and so forth, who was who, and then I would be able to advise you how to proceed.
Oh, okay. Then.
Okay.
Well,
that's
one quick question. Are you familiar with that new law, March 2013, where heir property does not go into probate?
Well, if you're talking about the transfer on death deeds,
yes.
Okay, yeah. We're trying to get there. I don't know if we're going to make it today, but that is one thing we were going to talk about today. Yes.
And
D.C. and Virginia have transfer on death deeds. That's a new law that is hugely important.
And we'll put information up on our Facebook page,
Okay.
Law Talk with Ethel Mitchell, so you can. We're going to probably run out of time on this show, but we want to take the next caller's question, Thelma from D.C. And then, so caller, thank you for your question. Please check our Facebook page or call Attorney Ethel Mitchell in her office for more information. Thelma from D.C., what's your question? Good afternoon.
Hi. My question is this. If you have a property and you got a divorce, and the divorce was granted, and the wife owned the property, and then she finds out later, 10 years later, there's a lien on the property. How can someone put a lien on a property that's not theirs, that was granted in the D.C. courts?
Again, you would look to the deed itself to determine who had title to the property and whether the lien was properly put on there. If it wasn't, then you would do what you needed to do to get the lien released. If, on the other hand, if the person's name was on the deed, who the lien is against, they may well have a right. I don't know. You'd have to look at it. We'd have to look at the deed itself.
Well, it was up to the judge. Judges don't always know real estate law.
Well,
they have court law.
Again, one of the difficulties that deeds have, especially when they've gone to court, even with probate, is a lot of personal representatives or executors never do a deed at the end of the probate so that the property goes from the deceased person's name into the names of the heirs that it should have been probated into. Same thing with divorce. A lot of times you may get a divorce. The judge may say, I give the wife the property, but if a deed is not done and recorded that puts the wife's name on the deed or takes the husband's name off the deed, then you're in a conundrum and you've got to get that done to get that title clear.
Well, that's not true in D.C. That is not the law. The law goes back to the court.
Well, honey, you go on and do what you think you're right. You go on and do what you think is right. But I know that it's the deed that governs title.
The deed that governs title.
Deed governs title. Okay. That's right.
Thank you, Thelma, for your question.
Mm-hmm.
So, Ethel, what is a life estate and how is it used?
Okay, I'm going to go really fast. A life estate means that one person owns it for life, and when they die, the remainder, they say who gets it when they die. Okay? And that's called a life estate with the remainder to the persons who are named. It's used a lot by parents to get property into the names of their children. Adult children, hopefully not. Or you can use it to make sure that somebody else has the right to live in the home for the rest of their lives. So, for example, a mother might say, I have a lot of clients who will say, I have one child that doesn't have a home. All my other children have homes. And so what I'm going to do is give that child a life estate in the property. We actually do a deed that says life estate to this child. And then when that child dies, it goes to the rest of the family. We have run out of time, so clearly this is a topic that is important, and we will try to bring it to you again at a later date. Thank you for listening in. Call me, Ethel Mitchell, at 202-772-1988, and I'll be glad to work with you to get your estate in the way that you want it to go.
Thank you, Ethel. You have just been amazing. I'm sure our listeners have really enjoyed you as co-host and guest. And so she'll be back next week. Make sure you tune in. 1450 WOLAM. Yes, I think so.
Maybe we'll do it next week. Okay. We'll continue this next week. Have a good week. Goodbye.